You know, it's funny how sometimes the biggest, most important ideas are locked away inside the most confusing sentences. Well, today, that's exactly what we're going to do. We're going to take one of those dense legal sentences and crack it wide open because it has huge implications for how some of the most serious lawsuits even get off the ground.
And here it is. This is our puzzle for today, pulled straight from a court case called Rose versus Bartle. Now, if you just read that and your brain immediately went, "Nope, what was that?" you are definitely not alone. It is jam-packed with legal jargon, but I promise you, by the time we're done here, every single word in that sentence is going to make complete sense. Yeah, that sentence feels like it's written in another language, because honestly, it kind of is. It's built for lawyers, for judges. But that's what we're here for. We're going to break it down piece by piece until it's crystal clear.
So here's our game plan. First, we'll look at where this rule even comes from. Then we'll tackle those key terms, pleading, racketeering, conspiracy, and that super important fraud exception. And then at the end, we're going to put it all back together and make it simple. Let's get started.
All right, so first things first, let's set the stage. This sentence we're looking at, it didn't just appear out of thin air. It's not from a textbook. It's a rule that was hammered out in a real-world court case, a real legal battle. And just knowing that is the first step to understanding why it's so important. So let's jump into the first big piece of jargon in our sentence, that word pleading. What in the world does that actually mean when a lawyer is just trying to get a case started?
Pleading is really just the official, on-paper start to a lawsuit. Think of it like the formal opening arguments. Way before anyone ever sees the inside of a courtroom, both sides file these documents to basically lay all their cards on the table. This is what we say happened, and this is why we think we're right.
Now, here's where it gets interesting. There are basically two different levels of pleading. On one hand, you've got standard pleading. This is like sending a quick text. Hey, you broke my stuff, you owe me. All you need is a short and plain statement. But then you have heightened pleading. This is way more like a super detailed, itemized invoice. You have to state your claim with, and this is the key word, particularity. You need all the specifics, who, what, when, where, right from day one.
Okay, so we've got the idea of pleading down. But what kind of lawsuit are we even talking about here? Let's dig into the next piece of our puzzle, which is the accusation itself. So when you see that legal-looking code, section 1962D, it's not just some random number. It's shorthand for a very big deal. It's a piece of the RICO Act, a law that was originally created to take on the mafia. So if you're filing the section 1962D claim, you're accusing someone of conspiring, of making a secret plan with other people to commit organized crime. This is a heavyweight, serious accusation.
Okay, so we have the rules of pleading, and we have this really serious accusation of a racketeering conspiracy. Now, it's time for the twist. The final, and honestly the most important word in our entire sentence, the one that changes the whole game. And this is it. This is the pivot point. The whole system turns on this one question. Is the organized crime you're alleging based on fraud? That single word is like a trigger. It decides which rulebook the lawyers have to play by, the simple one or the really, really hard one.
You can almost picture it like a flowchart, right? A lawyer files that big RICO conspiracy lawsuit, and they immediately come to a fork in the road. They have to ask, does our case involve fraud? If the answer is no, let's say it's about extortion or something, they get to take the easy path. They can use that simple, standard pleading. But if the answer is yes, if the whole conspiracy is built around fraud, everything changes. They're forced down that harder path and have to use heightened pleading, laying out every single detail from the jump.
All right, we've defined all the moving parts. We know what heightened pleading is, we know what a RICO conspiracy claim is, and we know about that critical fraud exception. We have all the pieces of the puzzle. So now let's go back to that original sentence and look at it with fresh eyes.
Here it is again. But this time, it probably doesn't look so scary, does it? Let's just read it one more time, knowing everything we know now. Section 1962D does not require heightened pleading as long as one does not allege fraud. See? It's starting to click.
And here is the complete translation. Let's walk through it. Section 1962D, that's our racketeering conspiracy lawsuit, does not require heightened pleading. That means, hey, you can use the simple standard rules and then the big finish, as long as one does not allege fraud. That's the giant unless. The second that fraud becomes part of the story, that easy path just vanishes, and the much harder, more detailed rule kicks in.
So the bottom line is this. Throwing the word fraud into the mix just raises the bar a lot. It makes it significantly harder for someone to even get their case started when they're bringing one of these powerful RICO lawsuits.
Which brings us to the big so what question. Why should we care about this? I mean, it just sounds like a technical rule for lawyers, right? But what does it actually mean in the real world?
Well, it matters because it creates this huge strategic choice for lawyers. It's a real gamble. On one side, accusing someone of fraud is powerful. It sounds really bad to a jury. But on the other side, if you make that accusation, you better show up on day one with an absolute mountain of detailed proof, which is incredibly hard and expensive to get. It forces them to weigh the power of their claim against the sheer difficulty of proving it.
And that really leaves us with a final, fascinating question to think about. Is this higher standard for fraud a good thing? You could argue that it protects people and companies from being destroyed by baseless lawsuits. But on the flip side, does it create an unfair roadblock, making it almost impossible for the real victims of complex, well-hidden financial crimes to ever get a shot at justice? It's not a simple answer, and it's something worth thinking about.